Hey everyone, it's Dave Peretz, the Fund CXO and founder of Signal Fund Services. Today I'm talking with Jonathan Fish, the CEO and co-founder of Cap Gains. Jonathan is a seasoned CPA and tax tech entrepreneur who works at the intersection of venture investing, startup tax strategy, and fund operations, something near and dear to my heart. So prior to launching Cap Gains, he spent over 15 years at PwC, where he focused on valuation and tax issues for private equity and venture capital firms. And at Cap Gains, Jonathan and his team have built a platform that helps VC funds and angel investors, founders proactively navigate the complex incentives of qualified small business stock. And today we're going to be talking about some of these triggers or moments in time when founders and fund managers should be thinking about QSBS. So excited to have Jonathan join us today. And I guess my first question for you is, why is everybody talking about QSBS right now?
Well, firstly, great to be with you. Thanks for having me on. And yeah, QSBS is definitely having a bit of a heyday moment, starting from the past few years, but especially over the summer. There's a huge expansion to QSBS in the One Big Beautiful Bill. So that came into effect on July 4th, 2025. And it's really the biggest expansion to QSBS since 2010. So what it did was increase the benefit and also increase the which shares are eligible as QSBS, or like which shares could be eligible. So a better benefit and more shares eligible. And so it's certainly a moment for QSBS. And in general, QSBS is a tax incentive designed to drive innovation. And so if anything, this is helping to expand that and to further innovation in America. So
I think that's an interesting way to frame it, as an incentive, right? And incentives definitely change behavior. And we probably will see, hopefully, some change behavior as a result of the QSBS changes, both as you call it, the 1.0 and now the 2.0. And so maybe the first thing we should do is kind of dive into some of those differences between the two types of QSBS, because as I understand it, fund managers will probably have stock that, especially if your fund's been in business for a few years, you'll have stock that qualifies under different, QSBS 1 or QSBS 2. And as a founder or an angel investor, as a founder too, you may also be dealing with these issues. So yeah, why don't you kind of walk us through what is the difference in the two and what are the benefits now of this new version?
yeah, and tracking that has become a challenge too. So with QSBS,
Yeah.
it's all based on when the stock was issued. So, and dating back to when it first rolled out in 1993, if you had stock issued a day before the rule came out, it doesn't qualify. So it's all based on when it was issued. And so what happened, like you're saying, this year, because the rule changed in July of 2025, any stock that an investor might have before that was issued before then is subject to a different set of rules, is subject to the old rules. And yeah, and so you might have stock in the same company where some tranches qualify under the old rules, some qualify under the new rules, and then you exit the company and you have to figure out, well, which shares should you sell, or if you have an opportunity to sell, which ones, how do you go about that? Do you sell the older ones first? Do you sell the newer ones first? If you have convertible notes that converted, maybe they converted after the rules changed, so they could benefit from the new rules. So there's a lot to think about and strategize about how to navigate it. I could pull up a couple of slides that we have on this.
Oh, great. Now I can see the slide that you're showing. It looks like a lot of difference between the two sets of QSBS 1.0 versus 2.0. So, John, why don't you walk us through what the slide's kind of sharing here?
Yeah, sounds good. So on the left side, under the QSBS 1.0 banner, is the old rules. So you used to have to hold stock for 5 years before the QSBS benefit kicks in. And so when it does, if you held stock for that long, your shares are subject to a $10 million exclusion cap, but 100% of the first $10 million in gains per eligible shareholder is tax free. And so at the federal level, that's 2.38 million in savings. Now you could also have state level capital gains tax, and every state treats QSBS differently. So for the most part, most states conform to the federal rules, and you could also have savings at the state level.
Can I ask you a quick question real quick before we jump on to the 2.0 rules? So you're a founder, you start your company, you set it up correctly, hopefully, which I'm sure we'll talk about in a little bit. But then through the life of the company, it grows and grows and grows. You'll make lots of decisions. This QSBS comes when you go to sell the position. And really what you need to do is kind of explain to the tax authorities why you deserve this tax treatment. And then if you're a fund manager, you also get to claim this, but you've got to do it for your LP. So now you've got another set of people that will want to use this information to share with their tax people. So it's a lot of people need documents and evidence to kind of get this tax treatment. And so I can understand why a lot of people care about it. It does take a long time to come to fruition. So I see that presents quite a few challenges.
Yeah. Yeah. I mean, with that, there are requirements that have to be met by the company, by the security, and by the individual shareholder. And so you really need all three of those to go right to be eligible. And there are lots of ways to trip up eligibility, which we could get into. So, and it's also important to note that this exclusion is per eligible taxpayer. So, think shareholders for a company or partners for a fund. It's the $10 million exclusion cap under QSBS 1.0. It's not at the fund level, but it's for each individual partner. So every partner in a fund could have that $10 million exclusion for every portfolio company that they have in the fund.
Yeah, that's very powerful.
Yeah. It multiplies a lot.
And I imagine the same is true for founders as they're thinking about their co-founders and their early employees. As part of your retention strategy and your hiring strategy, you can set those folks up for a nice tax treatment when, the company is successful down the road too.
Yeah, exactly. And I'm glad you mentioned early employees. It's key to think about that. Like QSBS is designed for the risk takers, so it's drive to incentivize risk taking. So whether you're the founder starting the company, early employees joining the company, early advisors of the company, or investors who get in before a certain point, that's who's being rewarded. And we'll get to it, but it's like the small and qualified small business stock is the measure of risk. So anybody that gets in while it's considered a qualified small business and gets actual stock could realize these benefits. Anybody who gets in after, QSBS doesn't apply.
That makes a lot of sense. So now looking at the orange banner here, QSBS 2.0, obviously much has changed with the new rules. Walk us through it a little bit.
So this is all what came into effect for stock issued after July 4th, 2025, when the One Big Beautiful Bill came into effect. And it's interesting because it has some elements of previous QSBS. QSBS started in 1993 as a 50% exclusion. The tax savings weren't that great, so they bumped up to 75% and then to 100%. So we've seen these exclusion levels over the history of QSBS. Part of the effective tax savings got negated because the second 50% or the final 25%, in the case of the 75% exclusion, is taxed at 28%, so higher than the capital gains rate. So it negates some of the benefit. But we show that in these savings. So like as the exclusion cap increased, the savings got bigger. So in effect, what's happened is the $10 million exclusion cap from QSBS 1.0 is now 15 million, and that's going to adjust for inflation after 2026. So it'll continue to increase. And then rather than having to wait 5 years to receive the QSBS benefit, the benefits start to phase in after you've held stock for at least 3 years. So after you've held it at least 3 years, but less than 4 years, you get a 50% exclusion level. After 4 years, 75%, and after 5 years, you're back at the 100% benefit, but now on a $15 million exclusion cap. So you could save 3.6 million as opposed to 2.4. Yeah, a good amount more.
And so do you think the fact that people can access the tax savings earlier, say year 3 versus year 5, do you think that will play out in how founders or investors put rounds together, how employees might ask for stock options, or is it just too early to tell at this point?
Well, we're seeing a lot of folks who are trying to see what they could do to get QSBS 2.0 stock instead of 1.0 stock. So it's definitely more desirable to have 2.0 because you have that shorter timeline and a bigger benefit and more potential use out of it, given the shorter timeline. So Now there are some ways that you could generate QSBS 2.0 stock potentially. So we've talked to a lot of folks about that. Some of the kind of more straightforward ones are, maybe you have a convertible note and the thought with convertible notes is that they're more debt-like and that the QSBS doesn't start until the notes convert to equity. So now suppose you
Right.
have a note, you could start working towards the 3-year QSBS 2.0 benefit. Um,
Mhm.
so, so it's a good time to convert notes like that, especially so like thinking about it from a funds perspective, if you could help influence the conversion of notes, now is a good time to do it. Similarly with safes, there's been for the last 10 years or so, a lot of people have been trying to help validate that a safe start counts as equity when it's issued, and which is an ongoing debated topic. But now with
Yeah.
these new rules coming into effect, you might prefer to only treat it as QSBS after it was converted to preferred. So it's
Mm.
another sort of opportunity that raises this strategic question as to how you treat different securities.
Absolutely. That makes a lot of sense. Okay. All right. So well let's change topics here a little bit. And what I would like to do now is kind of walk through the life of maybe either a founder or a fund founder, GP, and what are some of the critical moments that they should be thinking about where they should go, I need to check my QSBS checklist, or I know something should remind me I should go talk to Cap Gains. Like what are those life
Yeah.
events in the state of a company or a fund?
So let me flip to this slide for a moment. So this, just like you're saying, like along the life cycle of a company or a security, yeah, what should you be thinking about at different stages? What we've tried to do is help folks through this and not only get it right, but also identify these tripwires that could cause them to lose eligibility and identify opportunities
Yeah.
that can help improve their benefit. And so there are actions you could take all along the continuum here when investments initially made or when a company first starts from a company's perspective, we help perform a diagnostic. So like, does this look like good QSBS eligible company and eligible stock? And, a somewhat high level analysis, but using a bunch of data points to analyze like what the prospects are. And there are requirements that have to be met as well over the course of a shareholder's holding period. So certain requirements need to be met when stock's issued. Other requirements have to be met over the course of your holding period. We see a lot of different situations. Like one of the sort of tripwires might be during financing events. If a company engages in a secondary transaction, so where the new investors are, say they're buying Series B preferred stock, but they're also going to buy part of the founder's common and flip that into additional Series B shares, that could be viewed as a sort of constructive redemption, and where it's economically equivalent to if the company had bought back those shares and reissued them to the new investor. And from a QSBS standpoint, that's a sort of tripwire because there's a limit as to how much a company could redeem without causing other shares to not qualify as QSBS.
I've experienced that myself a couple of times in the last few weeks where either notes or safes or there was something that needed to happen and some sort of conversion. We get right to the point where we're about to circulate the final docs and someone comes in with, either a deemed sale or the constructive redemption you were talking about. And we have to sit and critically think through like the mechanics of the actual deal so that we don't disrupt the QSBS. That's happened recently, but I imagine we probably missed it on some at some point because I can't imagine that every attorney is perfect on every aspect of everything. So I definitely see the value in like getting a health checkup before some of these deals go through.
Yeah. Yeah. And I mean, just like what you're saying, it's such like a niche part of the tax code. And it's part
Yeah.
of the tax code, which like a lot of corporate attorneys aren't that familiar with to begin with, so they could be working on a
Mm.
deal and not realize that some of the actions being taken as part of the deal could trip up eligibility for either company or certain shareholders. So to be aware of those is sort of the first step. And so that's like when we think about it, it's more a diagnostic that would help to identify if there's a risk like that. And then, like you were saying, there are different ways to work through it. They're kind of
Hmm.
vary by situation, depending on who's on the cap
Right.
table, what is this, is the company still QSBS eligible? So that, like, they're all different factors that you need to consider in every situation to figure out like the right way to navigate it. But it's the type of thing with all types of QSBS situations and capital gains situations. Once the exits happened and or the transactions happen, can't really go back and change it.
To take it back, so you're a founder, you're starting a company, there's some critical decisions. Obviously, we all say you should consult your tax professional, you should consult cap gains. You want to make sure the company is set up correctly. And there's a fairly clear checklist, and with some good expert help, you can make sure that your business model is applicable and like you're doing it correctly. When you get to your first equity deal, your lawyers are going to ask you if you're comfortable signing some reps and warranties. Oftentimes, I see QSBS reps and warranties in the signing documents. I think you definitely want to make sure you understand what you're signing for there, and you might do that at every round. And so there's a lot of times where you have to sit and critically think what information you're relying to your employees and to your investors. Signing these very serious documents. Are you accurate, right? And I think it's definitely a good idea to get a health check there, right?
Well, exactly. And I mean, just the way the QSBS rep is written, yeah, I mean, you have to be a lawyer to understand what it's even saying, or at least familiar with that part of the tax code. It references the tax code. It references some of the regulations that build upon that part of the code, and then you have to know how to test them, and
Mm.
how to interpret and test some of these things. So there are all these different areas across the company's life cycle where QSBS comes up in different ways. And so to your point, like one of the things I've done is build an analysis for the time of financing rounds to say, oh, hey, company, you're being asked to make this rep. Let us take a look at it first, piece together a series of tests to see if it looks like there's any risk in making that rep the way it's written and in accordance, and based on the company's operations and the way that financing round is being structured as well. So there are a few things to look at, and but it could go a long way in helping to make sure that the reps being made comfortably. We've seen a lot of situations, Dave, where companies made that rep, and we look at it a few years later with either the company or with their some of their investors in the round, and see situations that the QSBS was really tripped up during that financing event.
Yeah, that seems like that would be very awkward to have a lot of people looking at you when millions of dollars of tax has to now be paid out that didn't necessarily have to be paid out before. I could totally see in that being a cold sweat moment. Now we get to the fun part, right? Now we've done the initial investment, we've done the initial testing. Through our holding period, we're continually checking in, especially where it's applicable to us, to make sure we're not losing our status or that we understand what our status is. Then everything's successful, as it always is in venture, and we get to the exit. And now we've got an exit event. And what is everybody doing at the exit typically for QSBS? Like, who are the players involved? What are the steps? What should people be thinking about for your specific lane?
Well, again, you want to look at it before the exit, because there are different. After a company is sold, you might not have access to the information. Whether you're the company founder or investor. So part of it is just having the right access to the right information so that you could put together the analysis. But hopefully by that point, we've been working with you and pulled everything together each year, and it's known what qualifies, what doesn't. However, a lot of situations we look at, that we work on, the first time we're looking at this company is as they're going through an exit. And so what we'll do then is a historical analysis and look back from the company's inception through now, reviewing the tax returns, putting together the series of tests to prove out if and when the QSBS criteria were met, and if there were any situations that caused stock not to be eligible, and put together what we call a compilation report, which is basically like a data gathering exercise of pulling all this into an analysis to demonstrate why it looks like all the various QSBS tests were met. When there are gray areas, there's a lot of gray area in the QSBS rules that kind of warrants an interpretation by a tax attorney. So there could be situations like that come up, or a company's specific situation. Are they in a qualified trade or not for QSBS? There are a bunch of types of businesses that are excluded from
Yeah.
QSBS. And so that is sort of more subjective and more based on existing case law. And so putting that piece together. So the way we're structured, we have a legal arm as well, where we one
Huh.
identify those issues, but then two, with the on the legal side, help to address them, and that could take several different forms. It's not always that a tax opinion is needed. It could be a memo regarding a particular issue, and then suppose you get through all that. It could make sense to then for a particular shareholder to have a tax opinion. Tax opinions have all different levels of authority associated with them. So in a tax opinion, you'd say, well, what level of authority do you have for claiming this on your tax return or taking this position on your tax return? And
Huh.
so it could warrant a tax opinion. The sort of like last line of defense that that we've worked with company founders and investors on is insurance to protect their tax
Huh.
savings. Like, that anyone who claims QSBS is generally subject to a potential 6-year window where that claim could be audited.
So in this case, who is buying the insurance? Who is selling the insurance? How does that work?
Yeah, so the buyer is really the party that's being protected. So the person claiming the benefit. So usually
Perfect.
in not it wouldn't be the necessarily at the company level or investment fund level, but the individual who's claiming QSBS. QS can only be claimed by an individual US taxpayer. So it's all claimed at the individual. There's no, which is another area to cover, but there's no reporting by the company of QSBS. Nowhere in their tax return or tax reporting do they say that they're QSBS eligible. It's a benefit claimed by each individual taxpayer who holds stock in that company. So they'd be the ones benefiting from this type of insurance.
That makes sense. Okay. All right. So we covered a lot there. So initial investment, run a checklist, talk to an advisor, get some good advice, and set it up correctly. During the holding period, there are several triggers, usually around financing events and or pivots in your business. If you change your business model, maybe you move into an unqualified trade or business. Like there are things during your holding period that you as a either business owner need to be aware of or as an investor need to be aware of. And then before you get to the exit, there's some homework to do, some preparation, some data gathering, potentially writing tax opinions, depending on the circumstances. And then as a fund manager, I would potentially gather some of this information up and share it with my LPs to help them make their claims on their taxes. And as a founder, maybe my company helps some of our early, qualified employees that have this exclusion do some of it. But that's generally the process for most people is they don't experience it until the exit. Is that fair?
Generally, but you want to think about it because there are also planning opportunities. And I mean, it's
Yeah.
interesting,
Okay.
all the list of people you read there, that there's there's so many parties that are affected by QSBS, and it all comes down to, is this company eligible to issue QSBS stock? And then who who could potentially benefit from that stock, like which shareholders, and then working through their own personal situations. What state are they a taxpayer in? We have situations of employees that got stock who are moving to outside the US. Should they move back?
Yeah.
All types of different personal situations and sort of planning around this.
So what in your mind are some of those critical planning aspects? Like what times in the company or the fund's life cycle do people need to do this planning, or what are some events or triggers that they might recognize where they should go, oh, I should reach out to Jonathan for get some help on this?
Well, I mean, we try to structure wherever you are in your life cycle, it's probably makes
Nice.
sense to look at this. We're working with some founders now who started in their second company and want to make sure that it's eligible.
Mm,
So what should they be thinking about as they started, or maybe they already started and they set up as an S corp, and when should they convert to a C corp, and how should they go about that conversion? 'Cause, in order to be QSBS eligible, the stock has to be issued by a C corp. So from the
right.
earliest stages, and that's at the company level. If you're an investor, you know, if you have a portfolio of securities, we suggest taking a look at them now. We do this sort of one-time portfolio audit to see, well, what are you
Mm,
dealing with? What sort of risks are in there, and then could help address those risks over time, or address those situations. One thing, we didn't touch on when we're talking about the new rules, but like another sort of trigger now is brought about by the change in rules, where under QSBS 1.0, the threshold for what is and isn't QSBS, it's still the aggregate gross asset level of the company, which is measured on a tax basis of assets. So think like balance
mm,
sheet, but adjusted for certain book tax differences. So that was 50 million. Now under QSBS 2.0, it's been increased to 75 million. And now, just like the benefit, that's going to increase for inflation over time. So by 2035, it's going to be close to 100 million. And so what that's causing is, if a company, say, crossed the $50 million threshold before the rule change, so like this example, the Series A doesn't qualify as QSBS because it exceeded that threshold, the aggregate gross asset threshold. But now line's been moved, the threshold's now 75 million. As long as the company hasn't crossed that threshold, any new equity that they issue, say they do their Series B and they're still under that threshold, that those shares could qualify. So you have this sort of
mm.
dead zone of stock that doesn't qualify. So one of the things to be aware of with this, and also sort of some of the associated trigger points with that, get at, well, or how are assets being measured? One of the other components of the rule change was uh, companies no longer have to capitalize research and development costs. So we work with a bunch of
Mm,
bioscience companies who they they crossed the gross asset threshold partly due to the capitalization of R&D. But
mm.
now, not only could they expense the R&D, but they could restate the last few years tax returns and bring that asset balance back below the QSBS threshold.
Hmm. I mean, I think that is a perfect example of why it's really hard to get blanket advice in QSBS land. And what you have to do is basically say you should consult, Cap Gains or your CPA, your tax advisor, to start the process of getting ultimately to the specialist, because it is incredibly nuanced, but it is millions of dollars in potential windfall for your employees or your investors. So yeah, I totally get why we need experts to help us with
Yeah,
this.
yeah, there's a lot of nuance. And I mean, really part of the reason why we started our company is because we saw people only looking at this upon an exit. And not only
Mm,
encountering then tripwires, there are things that tripped up eligibility, a few years ago, but they also missed out on the opportunity to leverage QSBS proactively to help potentially in fundraising, and it's not necessarily going to be why an investor invests, but it's the type of thing that an investor will want to benefit from. so proactively make sure that you're eligible and teed up to provide support to those investors.
Jonathan, one of the things that's kind of been on everyone's mind the last 6 months or so, and I think specifically it's relevant now with the one big beautiful bill and this changes to QSBS, is secondary sales. And a lot of GPs are exploring both GP-led secondaries as well as other forms of secondaries in order to drive liquidity for their LPs. And so I'm curious what your experience has been, or what guidance or advice you'd give to GPs that are starting down this secondaries path.
Yeah, well, liquidity, certainly had been pretty sparse for a while, and
Yeah.
secondaries are a great way to do it. We happen to have worked with a large investor or a large VC who did this type of secondary. And there are a few things that need to structurally be organized to enable while qualifying as QSBS. One key one is uh, you you can't claim QSBS by just selling the partnership interest. You have to actually sell the underlying equity. So you need to structure it in a
Mm,
way where you could sell those shares. And if the company is not going through an exit, which, if you're doing one of these secondaries and selling the whole portfolio, odds are most of the companies aren't going to be going through through an exit right now. So I know in this case the fund needed to get approval from each of the companies to sell their underlying equity, and then and to also structure the secondary in a way so that the new investor wasn't buying the partnership interest, but is now buying these shares. And so one is structurally making it work for QSBS. Then another two is, well, which securities in the portfolio are QSBS, and how do you go about proving it? So in our case,
yeah.
we run our analysis. We work with the venture fund. They helped gather a lot of the data necessary to run our tests and prove eligibility. So we could do that. Another sort of step in the process is to send the company a QSBS questionnaire. We enable this through our platform, but and these are commonly used by venture investors typically to request information about QSBS from the portfolio company. But I know in the situation I'm thinking of, we sent out a bunch of these, and some of the
Mm,
companies, weren't comfortable completing it or weren't comfortable completing it fully, even if the stock looked like it should definitely qualify as QSBS. So, but we view it as more of an additional data point to help in the validation process, not the sole data point. If we tell the
sure.
IRS, oh, how do you know this is QSBS? Well, we got this rep from the company or questionnaire. It's somewhat incomplete because they'll want to see, well, especially if it really looks like it's not QSBS, to have that additional diligence performed by the shareholder to demonstrate, why you think your stock qualifies. So we take that approach. We'll run our analysis plus gather this information from the company as an additional layer of support.
Kind of to bring this home a little bit, something I've been thinking about both through this conversation and before, as you and I have talked, is, well, how do I get started? Like, how do I start introducing this to my GP if I'm a fund operator hearing this episode here? How do I bring up the conversation with my GP? What do we talk about? And conversely, if I'm a platform person and I'm thinking about programming for my founders, what's a great way to engage with the founders? What's a good programmatic thing that you guys offer, that funds could take advantage of, or portfolio founders could take advantage of?
Yeah, QSBS is the type of thing where, like we said before, all parties stand to benefit if you could get this right. So,
Yeah,
for the GP of the fund, they want to make sure that they're that they understand what could be QSBS eligible across their portfolio. Some of the funds we work with want to, as well, make sure that they're not selling stock right before the 5-year holding period was met, or make sure that they
yeah.
understand kind of where they're at with regards to QSBS, so they could um, help to uh, sort of try to ensure that they're able to maximize the benefit.
So it's basically like prior preparation kind of enables good execution for GPs. And I definitely think your LPs are going to want a nice compilation report or some sort of documentation to go get their $3.75 million in taxable savings. So yeah, I can definitely imagine being prepared will make your relationship with your LPs much better.
Yeah, and actually, I forgot to mention it, but the K1 reporting rules changed a couple of years ago to
Mm,
improve the transparency as to how QSBS is reported. Like, funds are sometimes in
mm,
a tricky position because they're 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 the ones with the relationship with the portfolio company, and they're partners and limited partners are relying on them for information about QSBS. So the K1 reporting rules changed to help ensure some consistency with how QSBS is reported. So it's required now for funds to report it out to their limited partners, and there's bit of a discrepancy in how that's practiced, but in general, the fund is having to get comfortable with this and provide information out. And at the same time, more and more limited partners and investors have become attuned to QSBS, especially with the benefits having increased, and are looking to the funds that they invested in to provide information to help them get the benefit. So we've seen situations as well where the fund had a gain and didn't report it out as QSBS, and then has a bunch of LPs reaching out and saying, "Hey, shouldn't this be QSBS? How, like, why aren't you reporting this?" And because it's effectively like a 30% increase in the after-tax cash flow. Now another reason that we didn't talk about that for GPs is the rollover provision. So if you have a QSBS gain, you could, and you haven't met the 5-year holding period, or maybe you did and you had excess returns, you could reinvest that into other QSBS stock. And so if you're a fund that was recycling capital, you could potentially do that on a tax-free basis with QSBS.
Yeah, the other part we were asking is, so we just covered fund managers and why this is important in the preparation beforehand, so you don't just get caught off guard when your LPs ask you for this information. It would be pretty catastrophic if you're like, sorry for your taxable, tax payment you have to write to the government. It's because I just didn't do my homework or I wasn't prepared. That's not a great thing to say to your LPs. But now let's switch over to the founders. So what are some things that founders should think about and do to make sure they're taking the most maximum benefit, both personally for themselves as individuals, but then also for their immediate team, the other risk takers, as you say?
Kind of comes down to the same thing: proactively knowing, does this qualify? There are planning actions those shareholders could take. So if you're thinking about a company's employees, maybe they have stock options. Stock options need to be exercised before QSBS kicks in. So some companies are offering the ability for employees to early exercise their options to start the QSBS holding period. So that being one strategy. You could
Interesting.
you could also personally plan around QSBS. If you were to gift some of your stock to a family member, to a trust in your name, they get um, uh, they step into your shoes as though they held the stock since you held it, and get the a separate benefit. So instead of now $15 million exclusion, you could have 30 million of exclusion. But that all
Yeah.
that has to be planned for in advance. And another one, like I said before, the state tax rules are uh, vary. So maybe you're working from a state or live in a state that doesn't abide by QSBS. New Jersey was a state like that until recently. It was kind of overlooked with the one big beautiful bill, but around the same time, I think during the same week, actually, the New Jersey started to allow QSBS. And
Mm.
so we had a bunch of founders who were living in New Jersey, maybe right across from New York City, thinking, "Oh, should I move to New York so I could benefit from QSBS?" And that is a possibility. They could do that, but you have to do it well in advance of an exit. And so these are all types of
Yeah.
things, like some as to why you look at this early on, but also and how it could benefit you as a company founder.
I think we've covered quite a bit today. If people would like to get in touch with you and talk about your services, learn more about this, figure out whether they're a founder or a fund manager, what's the next step? How do they get in touch with you, and what's the usual kind of next step for you?
Yeah. So I'm Jonathan, Jonathan at capgains.com, CAPGAINS. qsbs.com. So feel free to email me or come on our website and there's contact us form. We also started QSBSexpert.com. So another way to contact us is through that website, which is more informational about QSBS. And then really the way we could get started is through our platform. We could run a diagnostic of your securities and help start to take a look as to look under the hood, see what you're dealing with.
That sounds great. Amazing. Well, thank you so much for sharing your knowledge with us today. There was a lot of it there, and I think this is a topic that's going to change venture. Whenever we change the incentives, there will be changes to venture. And so I think we should stay close to this topic and look forward to continuing to work together ourselves and then also continuing to share information about QSBS.
Sounds good. Thanks so much.
Awesome, man.